Hi, I'm attorney Jill Ruane. In today's class in 2-Minute Law School, we are talking about types of trusts. A trust is a legal arrangement where one person, called the trustor or the grantor, gives property or assets to another person, called the trustee, to manage for the benefit of a third person, known as the beneficiary. Trusts are commonly used in estate planning to manage assets and distribute wealth. But there are very different types of trusts, each serving a specific purpose. 1. Inter vivos trust. An inter vivos trust, also known as a living trust, is a trust that is created while the trustor is still alive. The trustor transfers assets into the trust, and the trustee manages those assets for the beneficiaries according to the terms set out in that trust. The key benefit of an inter vivos trust is that it helps avoid probate court, the legal process that happens after someone dies, so the assets can be distributed more quickly and privately. There are two types of inter vivos trusts. First, a revocable trust. The trustor can change or cancel the trust at any time during their lifetime. And second, an irrevocable trust. Once the trust is created, the trustor cannot change or revoke it without the beneficiary's consent. 2. Testamentary trust. A testamentary trust is created through a person's will and only takes effect after they die. It's written into the will, and the assets are transferred into the trust after the will goes through probate. Testamentary trusts are often used by parents who want to leave assets to their children but don't want their children to have full control of the assets until they reach a certain age. Since a testamentary trust is part of the will, it doesn't avoid probate like a living trust, but it allows the trustor to control how the assets are distributed after their death. 3. Charitable trust. A charitable trust is designed to benefit a charitable organization or the public at large. These trusts are set up to support a specific charity, a group of charities, or a specific cause. Charitable trusts are different from other types of trusts because they must be established for charitable purposes, such as relieving poverty, advancing education, supporting religion, science, humanitarian causes. There are two types of charitable trusts. First is a charitable remainder trust. The trustor and their designated beneficiaries receive income from the trust for a certain period, and then the remainder of those trust assets go to charity. The second is a charitable lead trust. The charity receives income from the trust for a set period, and then the remainder of the assets go to the beneficiaries. In summary, an inter vivos trust is created while the trustor is alive and can be revocable, which is changeable, or irrevocable, which is unchangeable. It's used to manage assets during the trustor's life and can avoid probate. A testamentary trust is created in a will, and it only takes effect after the trustor dies. It goes through probate and is often used to control how assets are distributed over time, especially to younger beneficiaries. A charitable trust is set up to benefit a charity or the public. It can provide income to either the trustor or the charity, with the remainder going to the other party after a set period of time. Each type of trust serves a specific purpose in estate planning, and the choice of which to use depends on the trustor's goals, whether they want to provide for their family members, support charitable causes, or avoid probate. Trusts offer flexibility and control over how assets are managed and distributed, both during life and after death. That's it! Be sure to watch my next video here in 2-Minute Law School. Class dismissed. But first, if you wish you went to law school or you just want to be smarter and win that next argument with friends, be sure to hit that subscribe button and ring that bell so you can get new classes when they drop.